Well, good morning, everyone. My name is Martha Zavala. I'm the president of the League of Women Voters, Pasadena area. And welcome to Thursday with the League, the U.S. Supreme Court, and redistricting, and the impact their decisions are making on our democracy. I'm sure you're aware that next year we have several consequential elections coming up. So as a league, as a nonpartisan league who does voter education, we're really gearing up to try to get out that vote. And one of the things that we need to understand, our very knowledgeable and dedicated speaker, Elton Wang, is going to be giving us his perspective on precisely what's been happening to our democracy as a result of these decisions. Because we're in California, sometimes we're isolated from some of the effects, many times not. And I think what we need to know is what's happening in our local areas also. Before I bring Elton up, though, I just want to go very quickly over our program today. The first thing that we're going to do is, of course, bring Elton up. And then you're going to be given an opportunity to ask questions. Some follow-up, maybe some things he didn't cover and you have that burning desire to know something, then you'll have that opportunity to ask him. We are going to circulate the mic that's over here so that we can hear you, that the audience can hear you as we're being recorded. And so the only way for you to get your question in will be for you to raise your hand, and we'll have somebody give you the microphone. Unless you want to walk up here when you get acknowledged and you can talk from here. But Elton will be standing here, so we don't want you fighting him for the mic. So you'll do that. Once we finish the Q&A, then we have two more sections of our morning's agenda that we're going to go through. And the first one is we're going to give you an opportunity to actually get right in there with our democratic process by taking actions on some pending legislation, because we need you to get in touch with your legislator to make sure that we either pass something or reject something, that they pass something or reject it. So following that, I'll have a few announcements about events that are coming up. And then if we have some time, because I really want to give time to Elton and your questions, I would like our board members to come up just so all of you who may or may not be new get an opportunity to see who they are, the fact that they're accessible to you, and that you can ask questions and maybe join one of their committees. The other thing I'd like to do, but I'd like to do it right now. How many of you are new this year? Please stand. So, following the program, I would like you to then stand up and introduce yourself, so don't let me forget that part. I'd like to welcome Elton Wang and have him come up here. I will be introducing him, telling you all, not all about him. It wouldn't fit on my page. Elton is a nonprofit advocate, a community organizer, and a congressional policy advisor who has worked on improving education, promoting civic engagement, and empowering our neighborhoods. He earned his BA in government and sociology from Wesleyan University and his GD from UCLA's law school. In 2022, he was elected to the governing board of the Pasadena area Community College District, Area 7. For those of you who are not familiar with that, maybe Marilyn, you are, it's Arcadia. And so as an organizer, he drove record voter turnout in California and across the nation to increase our political representation. As a congressional policy advisor, he worked to ensure that all immigrants have the opportunity to succeed in America. As a daughter of immigrants, yay. As an Equal Justice Works Fellow and attorney with Common Cause, our wonderful partner, he has promoted fair redistricting maps by addressing partisan gerrymandering through research, litigation, and policy advocacy. Today, he advocates for expanding voting rights and fairer representation to guarantee that all Americans can access their right to vote. And you know, this is a big deal for me. When we went through the census, I did not realize that not everyone's vote weighs the same, which is a real crying shame for communities of interest, especially those that have traditionally been disenfranchised. And it just really, it's something that I hope that we as a league will make sure our residents are aware of when that next census comes up or any redistricting efforts. Elton, please come here and lead the way.
Thank you for that lovely introduction. My name is Alton Wong. I am currently an Equal Justice Works Fellow at Common Cause on our redistricting and representation team. Common Cause has a long history partnering with the League, so I'm very proud to be here with you all today. Our history with the League has extended not just obviously with recent Supreme Court cases, but really over the last many decades in defending our democracy. As you may be aware, Common Cause is an organization that really focuses on advocating for a fair democracy, a more representative democracy through various issue areas, anything from what I do in redistricting to campaign finance reform, to making sure our democracy is strong because our media systems are strong, and various other issue areas. And so today I'm speaking specifically on a lot of the work that we have done this past year about the Supreme Court and as it relates to recent cases that impact not just democracy and redistricting, but really, in our perspective, the fabric of our constitutional system and our democratic principles. And so this is just a really quick topic overview of some of the things I wanted to mention. Two cases that were on the Supreme Court docket this past year and were decided by the Supreme Court this past June that have significant impacts on our democracy. A couple things about ongoing federal litigation as it relates to redistricting, because the work is never over, even though it feels like our redistricting cycle that just passed was already a while ago. And I'll mention just briefly a little bit of the work. There's a lot of things, but I'll pick one example of the work that we're doing here locally and in California, and then happy to answer any questions at the end of this. So I'm going to first begin with a case that I have spent pretty much the last year sleeping, breathing, thinking about every waking moment, and that is this case called Moore v. Harper. Moore v. Harper is a case that comes from North Carolina. And it is a case that's really focused at its core about redistricting. So North Carolina in this last redistricting process passed a gerrymandered map that we believed violated the state's own constitution. A powerful decision in North Carolina from a few years ago said that partisan gerrymandering, where you gerrymander maps in order to benefit one political party or another, or even a candidate or another, is unconstitutional under their state constitution. And so under that theory, we and many of our partners, including the League of Conservation Voters and a number of individual leaders in the state, filed a suit against the state, saying that their maps are unconstitutional. We had some early successes in this case where we were able to have the court rule both at the Supreme Court level of the North Carolina Supreme Court that the maps were indeed unconstitutional because of those illegal partisan gerrymanders. And as you may know, North Carolina is currently a very hyper-partisan state. And so the partisan leaders of their state legislature decided to appeal our win in that case, which we believe was a win not just for the people of North Carolina, but a win for communities of interest, which is an issue that both the League and Common Cause often talks about in redistricting spaces. And in that appeal directly to the United States Supreme Court, from the North Carolina Supreme Court to the United States Supreme Court, they appealed that decision under a theory that is we believe, reckless, baseless, ahistorical, completely without legal grounds, but they did it anyway, known as the Independent State Legislature Theory, or ISLT. One of my colleagues, Kathy Fung, who is our VP of Programs, likes to call it the BSLT because she thinks it's full of BS, which we agree. We absolutely agree. But this fringe theory should have never been taken seriously in the first place. And yet the court actually decided to grant this case a hearing and actually listen to this case on its merits. We vehemently opposed that at the beginning stages, but once we were entering that courtroom last December, we knew that we had to defend the way our democratic system works, which I'll explain in a little second about how this theory intersects with our democratic systems. But this radical idea, we believe, goes against the full 200 years that we've lived under our current constitutional system, because it not only upends the systems of checks and balances that we learn in our most basic civics education in elementary school about how the three branches of our federal government are co-equal branches of government. And this theory would not only upend that at the state level, it would effectively say that legislators would have unchecked power over potentially not just redistricting, but will open the door to federal election regulation and a number of other rules. And we were really afraid of the impacts they might have beyond this voting space. Once you start the conversation, it could really spin and spin and spin until it gets out of hand. So I talked a little bit about how this case got to the Supreme Court. We gave oral arguments. So we presented to the court on December 7th of last year. We were represented by former U.S. Solicitor General Neil Katyal, who argued the case on behalf of all non-state respondents. We had multiple parties involved in this case, and we all agreed that we needed to have a united front before the court instead of splitting time. And so we had a united front in front of the court with Neil giving the argument, really presenting the case as to why this dangerous theory is without precedent, is without basis in history, is without basis in constitutional text or law. And outside of the court, I wasn't inside the court, I was actually outside the court. We had a massive rally on the steps of the Supreme Court with the league and about at least 24 other organizational partners, folks that were bussed and took buses up from North Carolina to join us in that conversation, to really make it known to not just the media and the press that were present that day, but to our friends on Capitol Hill, who some of them joined us across the street, that this is a theory that has to be stopped, and we have to have those voices loud and clear. We thank the League, of course, and the other 40-some amicus briefs that were joined us in this case to make it clear to the court that we must reject this theory. It was really striking that the voices in opposition to this theory and with us in this against this theory was from all sides of the political spectrum. We had folks from the Federalist Society and the ACLU on the same amicus briefs opposing this theory, which just shows how radical and how unchecked this idea is, that in a time of hyper-partisanship in American politics, that this is the one thing we all pretty much agreed on, right? And so we were really excited that this year, in June, the court rejected this dangerous theory, and the court specifically said that the state legislators are not powers that are completely unchecked by any other system of government. In fact, they are in themselves bound by state constitutional restraints when they exercise their authorities under the federal or their state constitutions. We, in this current climate of the current composition of the Supreme Court, we couldn't predict exactly what the case was going to land, how the case was going to land, what the outcome was going to be. Even though we felt really strong about our case and we felt really strong about the record that was presented, clearly the consensus in the legal community and the political community was pretty much uniform in this case. We just really didn't know. And we had months and months of planning about what would the outcome be and what would our response to this be. Because if the court were to have endorsed this dangerous theory, we would see states across the country not only redrawing their redistricting maps, blue and red states redrawing their redistricting maps, they would potentially be able to restructure the way elections happen. Right now in the United States, we know when we go to vote that on our ballots, we have both federal elections and state elections at the same time, local elections too, of course. And that in those ballot processes, those processes are all uniform. So it doesn't matter if I'm voting for the President of the United States or I'm voting for the next assembly member to represent our area. We know that I'm going to have the same voter registration deadlines. I'm going to have to, have the same requirements when I show up on the ballot day or when I mail my ballot in. If this theory would have passed, there could be a two-track system of elections. One for state elections, which would be bound under your state constitutions, and then one separate track for federal elections, which this theory would say the state legislatures have their own power and their own authority over, which of course not only completely upends what we understand as elections in the United States today, but would cause a lot of chaos, in our election systems and confuse voters every single time they go to the ballot box. And so we were really excited that this decision was actually an outright victory for our what we call the pro-voting parties in this case. We really, yes, absolutely a clear victory for American democracy. And what we were really proud of is that we knew that there was a chance that they might just reject this dangerous theory, but we don't know what else they were going to say. But not only did they reject the theory, they actually endorsed the arguments that our attorney, Neil Katyal, made during oral arguments, which is so important because it not only says that this theory is bunk, we can't ever implement this theory, but it says that not only there's no basis in the law from now on into the future for us to consider this dangerous theory. And so the court, by reaffirming the fundamental role of state constitutions and state courts in the redistricting process, ensures that the actions of state legislatures cannot just be unchecked, cannot run on their own accord. They must still answer to their state constitutions. The notion that state legislatures may be able to exist independently of state constitutions is, I know, mind-boggling for most of us in this room, but that's exactly what was at risk in this case. And so by reaffirming these checks and balances at the core of our democracy, this case ensures that future redistricting processes, and including the challenges that certain redistricting maps are facing right now, which I'll mention a little bit later, can continue regardless if they're in federal court or if they're in state court. That state courts are still an important, viable part of our redistricting process, particularly in some states where the state court's actually involved in their redistricting processes. Minnesota has not been able to pass their own redistricting plans through the state legislature for, I think, 3 decades now. They've had to rely on their Supreme Court because of partisan gridlock, right? And so we depend on our courts, our state courts, for the redistricting process, which is so key. So we were really glad to see the court reject this theory. It was certainly a moment of elation. I wish I was at the Supreme Court steps when this happened, but I was actually on Zoom because, we are all over the country and the court releases their decisions at 10 a.m. Eastern time. I was barely awake at 7 a.m. our time. In fact, I was up an hour earlier because every day the court was poised to announce decisions. We would never know when things were coming. We had to be up and ready to go because we needed to be able to respond immediately. We had dozens of organizations and partners waiting for us, and after a decision would come, how do we respond? How do we talk about this? Because we know that it's important that when these cases come up, pro-voting organizations are uniform and unified. We have different perspectives, but we need to be sure that what we're saying about the dangers of some of these attacks to our democracy, we need to say that with a unified voice. So we're really glad to see the rejection of this case. And a couple things I wanted to highlight really quickly from the opinion of the case itself that we believe has additional impacts and additional pieces that really support the work of our democracy is three parts, aside from the lack of basis for this dangerous theory. One is that, yes, a state legislature may not create congressional districts independently of the requirements imposed by their state constitutions, which is what I just talked about. Second is nothing in the elections clause offers state legislatures a carte blanche there's a typo there, carte blanche to act in defiance of provisions of the state constitution. And were there any doubt, historical practice also confirms that state legislatures remain bound by state constitutional restraints when exercising authority under the federal elections clause. And so this means that, yes, there is the ordinary exercise of state judicial review. There's also the reaffirmation by the court of the right of the people to referend maps. Doesn't happen very often, certainly not in our recent history, but that is a right that the court reaffirms in this case, citing an earlier Supreme Court decision. It also reaffirms the role of the governor's veto in redistricting processes, not in effect here in California because we have an incredible independent redistricting commission, but in other states where that balance between the executive and legislative branches are actually very important when it comes to the redistricting process. And when I talk about Florida really quickly later, you'll see why. But they reaffirm the role of the governor's veto, which is really in effect reaffirming the role of the governor in the process. Even though the elections clause says the word legislature, it's really about the full governmental state process. And more importantly for us, the court reaffirms the right of the people to use the initiative power to create independent redistricting commissions, reaffirming a case from earlier last decade, Arizona v. Arizona. In that case, the court was actually kind of split as to whether or not it was permissible for the state of Arizona to hand their independent redistricting to an independent body like we have here in California. They barely upheld that process, but with this very clear majority, larger than the last time they decided this case, they said, yes, it is okay, it is constitutional for us to have independent redistricting commissions, which, I mean, was a massive sigh of relief to all of us, and something that you really had to read between the lines when the court was making this decision. These are just some words. I'm not going to read all of them, but these are some words of our leaders in this case. Kathy Fung, our VP of Programs in this case, said that today's ruling is a victory for all Americans who stand for democracy's promise of free and fair elections. And I also want to, of course, highlight our attorney, former U.S. Solicitor General Neil Katyal, who says, as we argued to the Supreme Court, the independent state legislature theory was contrary to precedent and would have called into question hundreds of state constitutional provisions and decisions. Today's ruling affirms the crucial role state courts play in overseeing federal elections. But that's not the end of the road. Just because we had this massive win doesn't mean the work is over, and certainly not at the federal level. There's two bills that we believe are still critical in this work in the halls of Congress. The first is the John R. Lewis Voting Rights Advancement Act, of course named after former Congressman John Lewis, who really was a champion of voting rights, perhaps the champion in his time in Congress. And this act would require states and jurisdictions with a history of discriminatory voting practices to have any changes in their voting practices pre-cleared. If anybody remembers the disastrous decision from 2015 that struck voting rights, that's an interesting sound, that struck down parts of the Voting Rights Act, this would restore Section 5 of the Voting Rights Act to ensure that if there are decisions that run counter to the open voting and the rights of the people to have open voting and fair redistricting, that they have to have those processes and plans checked before they go into effect. And the second is a pretty substantial piece of legislation known as the Freedom to Vote Act, and this would do so many things. It would go from actual voting and the act of voting in federal elections, by vote by mail, automatic voter registration, and things of that nature, and same-day registration. It would improve all of those practices nationwide. We currently have a patchwork of processes when it comes to our voting regimes. In California, we really do have really strong voting practices where if I had not registered to vote, I can show up and register to vote and vote on the same day. We have now, I know we say that our elections are weeks and weeks long because we get our ballots weeks in advance. I know I vote weeks in advance. But those aren't extended nationwide, and this bill would provide those protections and those rights to states across the country. And one piece that really is relevant to this conversation is that the Freedom to Vote Act would also place a ban on partisan gerrymandering nationwide. The reason why that is so critical is because currently federal courts can't actually even entertain federal gerrymandering cases. Unfortunately, in a case that has our name in it, Common Cause v. Rucho, from a few years ago, we lost the ability for federal courts to actually hear partisan gerrymandering cases. But what we believe that case says today, even though there was that unfortunate loss then, what we believe this case says today is that that means, as Chief Justice John Roberts at the time said in this case, that this is left for the states. And right now, any attempts for the states to try to attack our attempts to end partisan gerrymandering is far less founded, because the court said this is now up to the states, and so now we're taking it to the states. But this would, at the federal level, place a ban on partisan gerrymandering, which we know is so necessary in many states across the country. And there's also, in many states across the country, still work to be done within the state level, at the state legislature, such as codifying the role of the judiciary when it comes to redistricting and when it comes to elections procedures, banning partisan gerrymandering, as we have done here in California, and or implementing independent commissions, as we have done here in California. The next case I want to talk about really briefly is Allen v. Milligan. So Moore v. Harper was a case that was led in part by Common Cause. Allen v. Milligan is a case that was led by our friends in Alabama, by many folks, including the NAACP Legal Defense Fund, the ACLU, and a number of local organizations that really did a lot of the heavy lifting in the state, not just organizing, but also throughout this entire process. It was really incredible to see the power of their organizing while we were doing the organizing that we did for Moore v. Harper. So Allen v. Milligan comes from a case that's also a challenge to a redistricting map. And this comes from a challenge to Alabama's U.S. House map, so the congressional map. Alabama is 27% black, but only one of the 7 districts in the state, so 1 out of 7, is majority black. And in that case, as you can see, this map, that was the one that was challenged. You had one district currently represented by Congresswoman Terry Sewell that is majority black, and in this case, those community members are able to elect their candidate of choice, which happens to be a Democratic Congresswoman. And so the pro-voting parties in this case argued that this map, under Section 2 of the Voting Rights Act, dilutes the right of black Alabamians to elect their candidate of choice. So the Voting Rights Act of 1965 has 2 key provisions, one of which is currently not in effect because of a loss in 2015. But Section 2 of the Voting Rights Act, which still a lot of litigation is conducted under, says that you cannot abridge the right to vote, and you cannot dilute that right. So people need to be able to elect their candidates of choice. The legal theory behind that I'll go into in the next slide as to what you need to prove in court to show this. But the pro-voting parties brought this case with a really strong case, saying that looking at the lived experiences of the people in the state, looking at the way the map is drawn, looking at the history of discrimination in Alabama, which we know there's no shortage of, especially when it comes to voting, that this map must be struck down. The trial court in this case agreed with the pro-voting parties and struck down the map as a violation of Section 2 of the Voting Rights Act, which I mentioned already, says that no voting rule is allowed which results in a denial or abridgment of the rights of any citizen of the United States to vote on account of race or color. And the trial court said that there actually has to be created a second black opportunity district in the state of Alabama. So instead of just one district, there needs to be at least 2 in order to fulfill the commitments under Section 2 of the Voting Rights Act. And they said that this is required under a framework known as Jingles, which I'll go into right now. Thornburg versus Jingles from the 1980s was a case that actually had the court clarify how the Section 2 of the Voting Rights Act was to be applied, to be interpreted, to be proved, really, in a court of law. And so there are 3 preconditions which the pro-voting parties in Alabama satisfied under Thornburg versus Jingles. So they satisfied 1, that the minority group is, in fact, large and compact enough to constitute a majority of the voting age population in what would be a reasonably configured district. So how do you prove that? You would in many ways, take experts, so data experts, political science experts, to show that yes, I mean, it is just possible to draw a map that has another majority district that performs for this community, right? So it's very much a data-driven question. Second, is the minority group politically cohesive? And we look at that by looking at what is the history of voting outcomes for this community, right? Does this voting community vote as a block more often than not, right? And how does that play out in elections? And so is it the case that, for example, I don't have the percentage off the top of my head, so this is completely just as an example. Is it, for example, that 95% of Black Alabamians voted the same way in the last X number of elections? That's what that consideration is, of whether or not they are politically cohesive. And finally, the question is, does this majority group, so not the minority group, but the majority group, do they also consistently vote as a block to block the candidates that are preferred by the minority voters? And finally, if all those three preconditions are satisfied, looking at just a broad scope, the totality of circumstances, a phrase we use in the law way too much, does this plan diminish the ability of the minority group to elect candidates to office? And to prove that totality of circumstances, you can bring up things like the history of discrimination in the state. You can look at the legislative record as they are building that plan. You can look at the educational and social outcomes for that community in the state or in the region that you are challenging. And so the pro-voting parties were able to satisfy each of these criteria at both the trial court and later when the state appealed to the United States Supreme Court. So the court in this case, also a decision in June, affirmed the lower court's ruling that Alabama's 2021 congressional map violates the Federal Voting Rights Act by packing and cracking Black communities, resulting in diluted political power. So packing and cracking is something we talk about a lot in redistricting. Packing is the concept, is when you take a lot of voters that may be racially or ethnically cohesive, politically cohesive, and put them all in one district so that they will win that district with their candidate of choice, but it'll be with overwhelming margins because you know that if you put them all in one district, you can have your districts around for your side or your party or your preferred candidates. Cracking is where you take a district that if you put it together would be politically cohesive enough to elect a candidate of their choice, but by breaking them in half, you literally, in that case, dilute their votes and spread it out across a number of districts. And so the court in this case said that the state did this such thing. They packed and cracked Black communities in the state of Alabama, resulting in diluted political power, which violates Section 2 of the Voting Rights Act. Critically for us, the court also upheld Section 2 of the Voting Rights Act. Part of the reason why the anti-voting parties wanted to appeal this to the Supreme Court is because they wanted to dismantle Section 2 of the Voting Rights Act, just as they had dismantled Section 5 of the Voting Rights Act. And so it was critical that the court upheld Section 2 of the Voting Rights Act, and they, most importantly, rejected the race-neutral argument that the state of Alabama was trying to make. And so what that was saying is that the state of Alabama was saying, well, under the federal constitution, we can't consider race when it comes to this work, when it comes to redistricting. And the court specifically said, no, you can. There's other case law that says that it can't be the only reason that you're considering redistricting, but it can be a part of that process, and that in fact it is an important part of that process. And so, one critical thing about this win is that although, it doesn't really change the status quo very much, because the way that Section 2 has operated over the last decade will continue to operate in a similar fashion, but it's critical that even in the face of a more conservative court that had the potential to strike down the Voting Rights Act, the Voting Rights Act continues to survive. And so what this did was that by saying that yes, these districts violate the Voting Rights Act, the federal Supreme Court remanded to the lower trial court, sending it back to the lower trial court, which ordered a new map, saying that that old map from 2021 must be redone, must be redrawn. And so over the summer, we saw Alabama redraw their maps. And I use air quotes here because they redrew their maps, but the maps did not comply with the Voting Rights Act. They decided to, again, not just in this case, rebuff the trial court, or as they did earlier, but try to rebuff the federal Supreme Court in their ruling. And so in this case, the new map they drew, unfortunately, I don't have a picture here because I couldn't find one that was as clear as the last one that we saw. But in this case, they drew a second district that was meant to alleviate the violations from the prior map. But this new district would have a voting age population, which just means that people who are eligible to vote, so if you're 18 and a citizen, of black voters of only 39.93%. And the trial court, the last bullet point here, says that the trial court said that that map is still out of compliance. That map is still out of compliance because the communities in Alabama vote by such along such strong lines, regardless of whatever the political lines may be, but they vote such strongly as a bloc that 39.93% is clearly not enough for the black community in southern Alabama to elect a candidate of their own choice. And the court said, the state legislature and the states basically said, okay, and they're appealing again to the United States Supreme Court in this case. And this is really notable because they just lost in June, and they are attempting again to appeal to the United States Supreme Court. We don't know the outcome of that yet. This is literally in the last couple weeks. This week is when the Supreme Court asked for additional briefing in this case to make a decision for themselves of whether or not to take the case or not. But it is really clear that the judges in the trial court said in their decision just a couple weeks ago, they said that the 2023 plan, so this new plan, provides no greater opportunity for black Alabamians to elect a candidate of their choice than the 2021 plan provided. They were very clear that this is still a violation of the Voting Rights Act. And so the court ordered a special master. A special master is someone that the court tends to appoint. So an outside party, that's not the state, that's not the plaintiffs in this case. They ordered a special master to redraw those lines that the court would then review and potentially implement for the state themselves. But that is still an ongoing process. They do have a pretty short window. We know the 2024 elections are right upon us. But this is the way that the state in this case is trying to delay the implementation of this case, because each election they have, to have elections under that old map, is an election where one side is able to win versus another, right? But for us, of course, it's a nonpartisan context. Our goal is to have black Alabamians have their voices heard and have their vote counted on par with the rest of Alabamians in the state when it comes to congressional elections. So that's Allen v. Milligan, another critical case that the Supreme Court heard. Those were the two main democracy-related cases on the Supreme Court docket this cycle. Both were wins. Both were incredible wins that we are truly proud of, and I think it's a testament to the strength of the voting community, the outpouring of support from the League, from organizations like Common Cause, and across the country, from local organizations as well, to make it clear that we cannot go backwards in our voting rights in this country. And that the court was, despite the current composition of the court, still felt that the arguments from the other side were too radical and too extreme to be implemented and would overturn too much of common practice and the way our democracy functions in the United States. I wanted to mention just a few pieces of federal litigation that are still ongoing. These are all over the maps drawn this last cycle, even though, yes, it is almost 2024, but we are still in court fighting over those maps. All three cases, actually, Common Cause is involved in. You'll see we are the named plaintiffs in two of these cases. The first is in Florida. There's a federal case, Common Cause Florida v. Byrd. Byrd is the current Secretary of State in Florida, where we challenged the congressional map as a violation of the 14th and 15th Amendments under the federal Constitution. We are literally saying that Ron DeSantis and the state legislature were being racist when they drew these maps. So we're not saying that it diluted the voting power, which they did. We're not saying necessarily that it moved us backwards, which they did. All true. But we were saying, you know what? They were actually racist when they did this. And so that's a really key thing that we're actually going to trial at the end of this month. I am flying to Tallahassee in a couple of weeks to make sure that we win this case. And I'll be remiss if I didn't mention that in Florida, there's also a state case called Black Voters Matter v. Byrd, that is also joined by legal women voters in that case. They are part of the plaintiffs in that case, which is bringing a challenge to also the congressional map, but under the Florida Constitution. And that actually resulted in a win at the trial court just a couple weeks ago. But as we know, they're going to appeal, and they have. And so now we have to wait for the Supreme Court of Florida to act on that case before we have some sort of certainty on what's going to happen. So two different theories challenging the same map for different reasons, all in effect to try to give Black Floridians in this case their rights to vote. Because what the government did, what the state did in this last cycle was take a Black performing district in the northern part of Florida that has a history of being a significant Black community, history of slavery, a history of lower socioeconomic outcomes because of the vestiges and the continued impacts of slavery. They broke that district up into multiple districts in order to dilute the voting power of Black Floridians. That's very much a cracking situation there. In Georgia, we have a case that is similarly also challenging the congressional map as a racial gerrymander in violation of the federal Constitution. That's still ongoing in the courts. In Texas, we also have a case joined by many, many parties. It's a very large case that challenges both state legislative and congressional maps as racial gerrymanders in violation of the federal Constitution. You'll notice that none of these cases are under Section 2 of the Voting Rights Act. It is not because it is not a viable piece of law. The court literally just said it is. But there are always different voting theories that are brought forward whenever we have a case. And obviously we'll go with what we feel is the strongest case. And we are looking forward to going to court in Florida at the end of September, in Georgia, likely in November, and in Texas, who knows? We're still waiting for the judges to actually have some movement in that case. But this is just a few cases that are still ongoing. Of course, New York still has their ongoing challenges, and other states still have their ongoing challenges. But just to show that redistricting is not a once-a-decade issue. It is an ongoing issue that will continue until we're able to have protections like we do here in California extended across the country. Because one thing that we are proud of our independent commission, even though not everybody was perfectly happy after the lines were finally redrawn this year, not a single lawsuit against the maps drawn by our independent commission, which is a testament to the work that they did hearing the people of California and drawing lines in response to the people of California. And finally, I just want to touch on one local reform that I have been heavily involved with, but that the Common Cause is very involved with, is that in the city of Los Angeles. I'm sure all of us have read the headlines in LA Times last fall when some council members were caught on tape making pretty racist statements about Black and brown communities in the city of Los Angeles. And that really finally galvanized the city to move to try to implement an independent redistricting commission. Currently, the city has an advisory commission, which this last cycle, the council said, thank you, but we're going to draw our own maps, despite a full process that, in fact, the Common Cause California, Legal Women Voters, Greater Los Angeles, many people were a part of that process. But now they're finally going to put on the ballot next year charter reform to implement not only potentially an independent redistricting commission, which we're pretty confident is going to move forward, but also potentially expanding the size of the city council, because we know that each council member in the city of Los Angeles represents more people than some state legislators in other states. Potentially, although we're encouraging conversations and pushing conversations for ethics reform at the city level, which is going to be so critical. I'm not going to go through each of these. This is just some of the things that we've called for, such as we need to make sure that there's clear ex parte communications bans, which just means that the commissioners in a future commission can't go around and huddle in a room with council members about how a map is going to be drawn. It has to be an independent process that is accountable to the people of the city of Los Angeles. And of course, the thing that we always beat our drumbeat on, that the league always beats the drumbeat on, is that they must prioritize communities of interest in the drawing of these maps, right? And so we were excited to present to the city council just last month and their ongoing conversations about this topic. But we know that the work that happens at the city of LA has impacts for our entire region, given the size and strength of the city. And what happens in that city is also reflective of the regions around us, right? And that there has been a very clear move in the state of California, even by local cities, and local districts, to move to things like independent redistricting. You know, two bills that I know will be mentioned a little later as well that just passed the state legislature this week is AB 764 and AB 1248. Those are two bills supported by both the League and Common Cause. We both helped author and push it. And these two bills would do two things. One bill would require the use of independent redistricting commissions in jurisdictions of a certain size, such as cities with greater than a population of 300,000, which would cover a number of cities that currently have their council members drawing their own maps. But also strengthen the criteria and the requirements necessary when a regular redistricting process is happening, regardless of a commission or not. Right? And those are two bills that would really clean up what we currently have as the Fair Maps Act, which we all helped pass a few years ago, but also ensure that independent commissions are going to become the norm here in the state of California, because we don't believe politicians should draw their own lines and draw their own districts. And so, we believe this is a trend, right, in California. We're extending this across the country. We're actively involved in conversations in Ohio. We're going to the ballot in Ohio to pass an independent redistricting commission. We are working in Pennsylvania with the state legislature to put on the ballot in the future election an independent state redistricting commission, because we know that this is how we have more voice for our communities on the ground and for redistricting to be about the people and not to be about politicians. So thank you very, very much for your time. I'm happy to answer any questions that you may have today.
I have a couple of questions. One, how likely are we to see the review of problematic states' maps before they're implemented, now that we have this history of lawsuits where the states are losing because their maps are so bad?
Yeah.
And two, I wanted to ask about ranked choice voting. I read things about how people are discouraging third parties and things like that because they'll split votes and do damage. But if you had ranked choice voting, wouldn't it address that?
Yeah.
And I'm wondering what your thoughts are on that.
Thank you. Two great questions. I'll take the first question. So in regards to what's going to happen in terms of this redrawing of maps in other states, it really just depends on how the process plays out. For example, in Florida, the state court case, both sides actually came to agreement that they were going to fast track this case, so that if the plaintiffs win, so if the pro-voting parties win in Florida, that they would have new maps before this next cycle. And of course, the other side says, they think they're going to win, so they don't care about if they're going to agree to that timeline or not. But that really depends on how the process plays out in each state, right? So of course, in the cases that we're a part of, we're trying to see change before another election cycle. But the reality is that court cases sometimes really do drag on, and they really do continue for quite a while, which is why we're just going to trial now in our federal case in Florida, because we had to go through many different motions. The other side is going to try to slow us down by trying to say that we don't have the right to even bring this case, even though we've worked in Florida and have members in Florida for decades. now. And so those are all tactics to try to slow it down, right? And for us, our goal has always been to continue to urge the court to say we need to continue to press this and we can't leave this behind. So unfortunately, it's a really case-by-case basis. But in places like Florida, for example, if the pro-voting parties were to win, there is a strong likelihood that we may see some relief next year, but it's really hard to actually predict that because it just depends on how the court moves and whether things will be appealed and where it'll be appealed to. And then your second question about ranked choice voting. Common Cause, we don't have an official position right now on ranked choice voting, not because we don't like it, it's just because what we believe is that every jurisdiction is so different from one another. And the needs of every jurisdiction, whether your state, whether your local city or municipality, has different needs right now. And so what we do is that depending on the state, we'll evaluate whether or not we support RCV. But it is, in fact, becoming a very, very hot button topic. Because you're right, it does alleviate a lot of the concerns we have when it comes to a crowded field, for example, regardless if it's for just the sake of an education for the voters about who's even on your ballot, right? It does allow voters to have more choice and more of a say. That we see pretty clearly. But it's still a reform that is kind of, I think, in some ways where independent redistricting reform was 2 decades ago, brand new here in California, and people are like, what is this thing? How do we deal with it? Now it's the norm. RCV is still very much in its early stages, and we always are here to support those proposals in those jurisdictions that would best serve the needs of that community there. We think that community-driven perspective is so critical when we think about RCV.
This lady.
Oh, yeah.
Hello, Mr. Wang. You mentioned AB 764. What was the other bill?
The other bill was 1248. So,
Okay.
yes.
Talking about independent redistricting commissions, I went out of state to try to sue California for cracking the Latino vote and the obliteration of Lucille Robal's seat, which I thought was very historical, being that her father founded the Congressional Hispanic Caucus. And even with the city, when I participated in that redistricting process, you have people like Paul Koretz pushing at-large seat, which is just unacceptable. And I'm really, really concerned with what's going to come out of the city of Los Angeles, because I'm also running for the 52nd district, which covers half of that district, and it is just fraction. And we have cracking within that. Just speaking of the cases, the majority Latino vote, and twice the last 2 elections, you have another majority party voting against the community's choice.
Yeah.
So I want to see how you can deal with this issue of the commissions and be appointed, and it's still at the at the leisure of someone who may also be biased.
Yeah, no, that's a great point. I mean, that's why we mentioned 3 things in tandem. We mentioned expansion of city council, independent redistricting, and ethics reform. Those 3 things need to go hand in hand for the city of Los Angeles, right? They're all critical in this process. One thing I'll mention is that in our independent redistricting proposals right now, and what the council is currently considering, would be a fully independent process where you would have ordinary residents of the city of Los Angeles apply, and we are encouraging it is the city clerk and the ethics commission of the city of Los Angeles to be involved in the process of selection of commissioners. It would no longer allow the council members to have a voice in that process. That's a really, really key point in the independent redistricting model. And in terms of being able to elect your candidates of choice, that's also why we really, really support expanding the size of LA City Council. Common Cause, we currently support pushing the council to move to a model where each council district has roughly 150,000 residents in it, which is markedly down from what it was before. This would result in approximately 26 districts, and we've done some mapping for the city of Los Angeles, just internal, nothing that we're going to release, but at least what it shows us is that that is going to be able to add at least 2 clear black opportunity districts. It would at least be able to add at least 3 to 4 Latino majority districts in the San Fernando Valley alone, of course in East LA, parts of South LA. So we believe that that's also another way to increase representation in the city council, right? If we expand the size of council to that rough number, what we will also be able to see is that Koreatown, which has been split multiple times over the decades, would not only be united in one district, but in fact, there would be an Asian Opportunity District in the heart of Los Angeles, which has never existed in the city of LA. So, for us, it's those three prongs together that's going to be very important. And we will be watching, and we are pushing the council to do those three things. Because if any of those three things don't happen in tandem, it won't be as successful of a reform for the council, right? So right now, the council's been really targeted, focused on the conversations around independent commissions. Fine, we can have that discussion, we can intently have that discussion, but you cannot forget those other two prongs of the conversation, which are so important. So, we won't support anything less than a fully independent commission, because we know that the advisory commission has done important work, but the council has to turn around and say, we're not going to listen to it. Yes, hi.
Elton, I'm so appreciative of what you're teaching us. Couple things. Why does a voting block matter? Why do they need to vote in the same way? And then, I've been telling friends for years, why don't we just put a grid over the state or go by the number of people or something to create a voting instead of all this manipulating and drawing little lines?
Yeah, both great questions. The first one, when you mentioned the voting blocks, that goes through Section 2 of the Voting Rights Act and the Jingles framework that I mentioned a little bit earlier. A voting block is important because we're looking at a community, right, that has been underrepresented or has been cut off from any representation at all. And it is both a matter from a court's perspective. This is not from a community perspective. I'm talking about a legal perspective, so not my personal one. That there needs to be a practical ability for that community to actually exercise their political voting strength. And if they can't do that, even if you would draw the maps, it would not be able to produce a district that serves them the way that we hope it would serve them, right? So that's where the voting blocks comes into perspective here. So let's say that in Alabama, if the black community in Alabama actually voted 50-50 or 30-30-30 for a number of parties, then that conversation will be much more difficult for us to have because it's not really cohesive anymore. And by showing that there is cohesion in that political outcome, in that voting strength and that voting block, we're able to say they are trying to elect their candidate of choice, but they're being blocked by the majority block here. And the majority block in Alabama also votes very consistently in the same direction, right? So this is not about partisanship. This is just about how the outcomes result and whether or not one group's able to elect the folks they want to see in office or not. And then your second question about the grid, I think especially with the advent of technology and computers and the improvements in data science, we do hear an urge to say, why can't we just let computers do this? Why are people involved in this process? And our argument to that is that redistricting is not just about a map. It is about our lived experiences.
What?
About our lived experiences, right? A district not only comprises a number of people. The district also comprises lived experiences, histories, shared experiences, economic relationships, social relationships, cultural relationships that need to show up, and a computer just can't factor those in properly, right? And so we think that it's important. That's why we stress the communities of interest piece so much, because a computer won't know that I live in Arcadia and that I shop, and most of my family and my community will go to that one giant plaza in San Gabriel to shop. That's actually an economic relationship between two cities that actually matters, right? Or that if I am in Arcadia and I am in Old Town Pasadena every other night, that is an economic relationship that matters. But that's just one example, right? We can go into cultural, historic, parkland. It could be a number of things that computers just unfortunately can't comprehend. But then if we think about a grid system, sometimes what we do is we bisect communities, right? Or we cut communities up that probably shouldn't be cut up, right? The city of Alhambra should probably be kept together in one district unless it's required otherwise, right? Sometimes some cities are broken up a little bit because it's required otherwise, or if you're the city of LA, you're way too big, so you have to be cut up a little bit. But we want to keep communities together, and if we do a more rigid model, it kind of creates more problems, we think, than it solves. It will solve the problem of fighting over a map, but then the people would be a little bit less represented. So, no, excellent question though. And I will also just note the advent of computers has resulted in hyper focus of gerrymandering, right? Because now I can literally pick one voter and move them into another district using a computer. And so gerrymandering has gone to a point in certain states where we have seen, for example, in places like Georgia and Florida, the state legislatures drawing people out of their districts for the only reason as to draw them out of their district, right? Instead of what we believe it should be, is to be community-led and community-driven. So computers, both great for us because now we can do our work better, but also very challenged when it comes to hearing the people. Thank you for that question.
It's fun to have such a knowledgeable person to talk to. And your last comment reminds me in the last election how we heard the results by neighborhoods.
Yeah.
Right? It was very specific. My question, I hope, will give me another chance to learn what you were saying about Allen versus
yes.
Milligan. And so my question is, what if the Supreme Court doesn't take the appeal?
Yeah. If the court does not take the appeal, it would mean that the trial court's decision stands and we will see new maps. So let's hope the court doesn't take the appeal and just like get on with it and draw new maps that actually comply with the law. So yeah, we are.
With that, what is Section 2? Would you?
Sure.
I'm not knowledgeable to know what Section 2 is.
Sure. So yes, it would draw a new map. So thank you for that question. And we would see this case, be kept in trial court, and they would administer the process. Section 2 is a provision of the Voting Rights Act of 1965. During the Civil Rights era, the Voting Rights Act was a key piece of legislation that really at the time upended how elections and voting happened in the US, right? It ensures protections for minority communities as just one aspect. There's many other pieces of it, but what's relevant today is that it ensures protections for minority communities when it comes to not just redistricting, but also voting procedures.
What does it say?
So, I mean, this is the language right here of Section 2. The entirety of the bill is very long, so but this is an operative portion of Section 2, which talks about voting rules that whether it denies or abridges the rights of any citizen on the account of, in this case, race or color. And so by doing that, what the legislature, what Congress at the time, and what Congress has reaffirmed multiple times actually on a bipartisan basis, is to say that you cannot implement voting rules and procedures that would negatively hurt or straight up deny the rights because of race or color, right? And so when you look at the language here, it does say voting rules. So this extends beyond just redistricting. Right now we see it very commonly used in the redistricting context, but we can think about 60, 70 years ago where things where primaries were conducted in a way in Texas that were basically rigged from the very beginning, right? Or primaries that prevented people of color from voting in them. Or this could go to issues where we're talking about what your qualifications are when it comes to registering to vote, right? So a voting rule is broader than just redistricting, but in this case, we've talked more about redistricting under the Voting Rights Act. So the Voting Rights Act is very much still alive, I know in 2015, after our loss, and it cut Section 5 from its operating grounds, it's still very much a piece of legislation that there's a lot of active litigation under. A lot of active litigation. Section 2 can be used not just when it comes to a congressional map. Section 2 can be used if, let's say, I'm making this up, I am not accusing the city of Pasadena. If the city of Pasadena drew a district specifically for the reason of denying or abridging a person for account of race or color, the Section 2 of the Voting Rights Act is still a protective force in that case. Another question? I saw a few more hands.
Did a great job.
Thank you.
Thank you. I was taking notes. My name is Fonte Riddle, and I just wanted to say I appreciate this because my mother's family is from Birmingham, and generations slavery, and so my great-grandparents never voted, and my great-grandmother didn't vote. I'm sorry, my grandmother did not vote until she was in her 30s because in Birmingham there was one voting station, and you would wait for 7, 8. If you left the line, you could not come back. You could not be given any kind of comfort, and they had people up and down the line, primarily white men, that would ask you for your ID to determine if you should be in that line anyway. And so it was a lot of fear. And my mother never voted in Birmingham because she was forced to leave at 17 by the sheriff because she didn't know her place. My point of saying all this is what has changed. I have a real aversion to that whole state, for personal reasons, but I will tell you that I don't see a lot of difference for my family that still lives there.
Yeah. You know, that's a really great point, and I think a lot of the reason why we see so much strength and activity from pro-voting organizations and organizations on the ground in places like the Deep South is because we know that there are communities that we cannot leave behind. Right? We cannot leave these communities behind. No matter if the results of a presidential election in a state like California and Alabama, the moment the polls close, they already announce who's the winner. It doesn't matter if that's the case. We know that there are going to be lived experiences of people on the ground that we have to be able to help address and listen to, right? And if they have the right, if they are able in their local cities in Alabama to elect a city council that is more responsive to their needs, that will go a long way compared to where things were before, where city councils were rigged with at-large systems in order to deny particularly black voters from being able to elect any candidates to their city councils, right? We saw that in Texas, we saw that everywhere, including California, let's be clear. So I think it's precisely because there's still so much work to be done and because so much change has not yet happened that needs to happen, that these kind of fundamental parts of a democracy are so important to change and to make sure our people are protected, right? An additional member of the congressional delegation that would represent the Black Alabamian community in the halls of Congress would literally double the amount of representation they currently have in the halls of Congress, right? And Congresswoman Sue was a fantastic congresswoman. She has been a champion of our voting rights issues for a many number of years, but she is one person from her state delegation right now. And imagine the work that can be done just in the halls of Congress if they had more voices, right? I know, for example, in California, of course, we have a lot of members of Congress, but our members of Congress work together collectively all the time to advance the issues and the needs of our communities, right? And so that's just one small part, we think, that will impact the decision-making that impacts the state in the future. So, I mean, you're right, there's a lot more to do, a lot more work to go to, but without, we think, the fundamental parts of being able to vote and choose people that will make the change that you want to see, those future changes are even harder.
Our last question.
Okay, one of the principles you talked about with regards to Los Angeles City was the idea that more districts will make it more democratic because it'll be closer to the communities. A bigger example of that is the county of which we're a part, where there's so few representatives, each one, represents 2 million or more people.
Yeah.
And are you working towards smaller, redistricting within the county or other areas in California?
That's certainly a conversation that we are a part of. It's not a conversation that has moved very much recently, although we know that there are some supervisors that have made motions to try to look at this issue. And I believe technically there is a majority of supervisors that are interested in addressing this issue. They just want to address it in different ways. Two of them want to address it with broader reform of the county and charter at the same time. And then two of them primarily want to focus on the issue of expansion itself. So I think we see that there is a clear need for that conversation, because yes, the fact that one of our supervisors represents more people than many state governors do is quite a unrepresentative part of the way our county works. And so, we don't have a formal position on that yet, since it hasn't really, we haven't been able to move on that issue as of yet. But I do believe we'd be consistent with our position in the city. And I would just note that our position in the city is not just that it makes the elected council members closer to the people, it also makes sure that there is a more diversity of opinions on the city council, and that there are more views and more lived experiences that are able to be elected to the council. So thank you for your question. And thank you, everybody. Thank you for your time.
So again, thank you so much for this. It was so informative. You're gonna have to come back again. Where's our membership? I think she's out there somewhere. She's gonna hook you in. We need a lot of help, because there may be some of our local redistricting bodies that need help, and we're gonna help them. Okay, all right, next. I would like to talk about the chance to do some advocacy. We had, they talked about it, I think you have the handouts on the table, right over on that side. So if you weren't able to get the information from Elton, it would be great if you would go ahead and pick this up. Before we move on, I just want to thank Pasadena Media.
Martha, I need you to stay still.
Yes. I told you, I feel like a caged lion. Yeah, I hate standing back there. Yes. So, thank you very much for joining us. Don't go away, we're gonna have some other things, but we wanna close out our videotaping. So, thank you very much for attending. We really enjoyed this morning and hope that you did too. And so, have a really great National Hispanic and Latino Heritage Month. I know I'm gonna do it. And so, thank you for being with us today.